The Civics Debate. Battle Chief Justice. Brought to you by Asia United, the bank of choice. Shell, get the most out of every drug. The Malayan Insurance Company, insured to be sure. And ANC.
Good evening. Welcome to Square Off, the Civics Debates, where the most intrepid of our local politicians venture onto our level playing field and dare to subject their plans and visions to the challenges of competing ideas. Tonight, two of them go head-to-head to enlighten us all about the complexities involved in a raging controversy. With Supreme Court Chief Justice Renato Puno set to retire in the same month as the next presidential election, two schools of thought have emerged as to who can name his replacement. One camp says only the next president can do so, citing Section 15, Article 7 of the Constitution that says 2 months immediately before the next presidential elections and up to the end of his term, a president shall not make appointments except temporary appointments to executive positions when continued vacancies therein prejudice public service or endanger public safety. But the other camp cites a conflicting provision in the Constitution, Section 4, Article 8, that says the Supreme Court shall be composed of a Chief Justice and 14 Associate Justices. Any vacancy shall be filled within 90 days from the occurrence thereof, to back their argument that President Gloria Macapagal-Arroyo can appoint the next Chief Justice. Our proposition tonight, let it be resolved that President Gloria Macapagal-Arroyo must appoint the next Supreme Court Chief Justice. Our debaters for the affirmative side, senatorial candidate of the Lakas Kampi CMD, Attorney Drilon-Lambino. Good evening, Attorney.
Good evening, Twink, and good evening to our televiewers. Good evening, Senate President Drilon.
For the negative side, senatorial candidate of the Liberal Party, former Senate President Franklin Drilon. Welcome back, Senator Drilon.
Good evening, Twink. Good evening, everyone.
And we're using a modified Oregon-Oxford format for this particular debate. Each debater delivers a constructed speech no longer than 2.5 minutes in length in 3 areas: the proposition's constitutionality, necessity, and beneficiality. The opposite side then gets to ask one question pertaining to the topic, which the speaker has 1 minute to answer. One question may be posed by a panelist during each speaker's turn, but the question must be categorical and only clarificatory. Now, additional time may be granted at the moderator's discretion. Finally, each speaker has 2 minutes for a closing statement. I'd like to introduce our panelist tonight. He is Mr. Anton Peralta, senior partner of Cochinyan and Peralta, and a lecturer at the DLSU College of Law. Thank you for joining us, Anton.
Good evening to everyone. I'd like to correct that. Future lecturer at the future De La Salle College of Law. Okay,
I stand corrected. Now, we encourage you to participate in our live chat by logging on to www.abs-cbnnews.com/ANC live events using your Facebook or Twitter accounts. Now, let Battle Chief Justice begin. For the affirmative side, arguing the constitutionality of President Arroyo's appointing the next Chief Justice, Attorney Lambino, you have 2.5 minutes, sir.
Well, let me start by defining what the Constitution means. The Constitution is a written instrument by which the fundamental powers of government are established, limited, and defined, and by which these powers are distributed among several departments for their safe and useful exercise for the benefit of the body politic. It is clear, therefore, that the judicial power is in the Supreme Court and other courts of the land. The executive is in the hands of the President and the members of the Cabinet, and the legislative power is in the hands of the Congress of the Philippines, composed of the Senate and the House of Representatives. The issue now beforehand is about the appointment of the next Chief Justice and, of course, the exercise of the Supreme Court or the judiciary of its independent power to apply or review cases. Now, there is that position taken by some sectors that the president, the incumbent president, more particular President Gloria Macapagal-Arroyo, cannot appoint the next Chief Justice because of the ban stated under Article 7, Section 15 of the Constitution. Remember that Article 7, Section 15 pertains to the Executive Department, and it is very clear. The provision says that 2 months preceding the next presidential election and up to the end of his term, a president or acting president cannot make appointments. It did not say cannot make any appointments, no, except temporary appointments and continued vacancies shall prejudice public service or will endanger public safety. It is clear, therefore, that this particular provision does not apply to the judiciary. It does not apply to the appointment, more particularly to the members of the Supreme Court. Otherwise, we are going to violate the independence of the judiciary. It is clear that when the President issues appointment to the members of the judiciary, more particularly the Supreme Court justices, including that of the Chief Justice. The Chief Justice members and the Chief Justice and the members of the Supreme Court become independent, and they shall not be subservient to the President. Now, it is important to have a Chief Justice at this point in time when we are going to face these elections, and it is regardless of whether President Arroyo is the one sitting as a president. It is regardless of whoever is the president that is tasked to make that appointment. It is important that we should appoint the next Chief Justice, because we cannot afford to have an acting Chief Justice in the Supreme Court. Nowhere that we have an acting Chief Justice.
Senator Drilon, you may ask one question in the area of the proposition's constitutionality.
Is Attorney Lambino aware that in the 1998 decision of the Supreme Court, Valenzuela versus Vallarta, the Supreme Court precisely applied the prohibition on appointments to the judiciary?
Well, that case was decided by the Supreme Court sometime November of 1998. The appointment of Judges Valenzuela and Vallarta was issued on March 30, 1998 by then President Ramos. But prior to that, there were appointments issued by the President for 8 Court of Appeals justices. And during the deliberation of the appointments of these 8 Court of Appeals justices, the question arose whether or not the ban for the appointment of the members of the Court of Appeals should apply, meaning the provision of Section 15, Article 7. And Senior Justice Florence Regalado, retired Supreme Court Justice Florence Regalado, one of the most well-known authorities in constitutional law, said that the ban on the appointment of midnight appointments under Section 15 of Article 7 does not apply to the members of the court. And that was cited by the Supreme Court in this particular case of Vallarta and Valenzuela. And even the Supreme Court said so, that if there may be imperative instances that the ban cannot apply to the appointment of the members of the Supreme Court. And the Supreme Court, in that particular case, cited the instances whereby if there is diminution as to the number of the members of the court to decide on important issues, then the appointments can be made to the members of the Supreme Court by the President, even during the so-called election ban.
A clarificatory question from Attorney Peralta.
Attorney Lambino, the Chief Justice is set to retire on May 17.
Yes.
And the elections will take place on May 10.
That's right.
With the automation of the elections, by May 13, 14, or 15, we may already have a report from the COMELEC as to the probable winner of the elections. My question is, with this question regarding the constitutionality of the appointment of the next Chief Justice still undecided, or because of the conflicting views regarding the constitutionality, don't you think the President, if she appoints Chief Justice Puno, appoints the next Chief Justice, would unduly tie down the next President with the legality of this issue?
Well, I don't think so, sir, because remember that the purpose of the ban on midnight appointment is not to tie down the executive, the next chief executive of policies of the previous administration. The Supreme Court justices or the judiciary is a separate branch of government. We cannot apply the fear that was laid down by the Supreme Court in the case of Aitona versus Castillo, because this referred to the appointments in the executive. And if the next Chief Justice is not appointed after May 17, then the term of office of the President will expire only on June 30, 2010. The convening of Congress will be on the 4th Monday of July. We should be convening the Judicial and Bar Council to nominate